in determining whether to revoke supervised release, may a district court account for these omitted factors? SCOTUS versus the United States. Eduardo Esteras pleaded guilty to conspiring to distribute heroin in the district court, and they sentenced him to 12 months in prison, followed by a 6-year term of supervised release. However, while on supervised release, Esteras was arrested and charged with domestic violence and, well, other crimes. The district court revoked Esteras' supervised release and ordered 24 months of re-imprisonment, explaining that Esteras' earlier sentence had been rather lenient and that his revocation sentence must promote respect for the law, a consideration enumerated in 18 U.S. Code subsection 3553, and you can figure out the rest of it. That sounds like a bit of like the district court had buyer's remorse a little bit. What do you think, Chance?
Well, that's a possibility, or the district court that originally sentenced him leniently may have left the bench. But nonetheless, the Sixth Circuit affirmed, holding that a district court may consider section 3553 sub A sub 2A when revoking supervised release.
Well, then I guess the question is, in this case, for the Supreme Court, in determining whether to revoke supervised release, may a district court account for these omitted factors? And that's specifically the numbers and letters you read a moment ago, 3553A2A. Esteras says no. The government says yes. What did the High Court say?
Well, they agreed with Esteras. District courts cannot consider section 3553A2A when revoking supervised release.
So when a person has exited the Federal Bureau of Prisons on supervised release, we're no longer punishing them. Or the way you read here, the way this appears to read, we're assisting them. Is that correct?
That's right. It's all about rehabilitation. Correct.
So therefore, the United States Supreme Court seems to have spoken clearly that if you didn't get your pound of flesh, you can't, district judges, you don't get to have buyer's remorse.